Good morning, everybody. So I'm hoping that I will persuade you by this presentation and training that Kelly has saved the best for the last, at least the last week, because the idea of using a federal law to make a lot that's a fairly easy legal uh, legal procedure, but new to us generally because we don't often practice in federal court, and can result in very uh, very fun and large money judgments for both our clients and funding for our programs actually is something that we don't often get a chance to do. But generally when legal services lawyers do this type of work, it's a successful income, it's a successful outcome and income for our tenants and for our programs too. And so this is also something that you can let your directors know. Yeah, could very much help your programs in terms of their funding. But that's not the reason that I'm a crusader for trying to expand, for urging people to expand your housing law practice to consider these types of lawsuits. It really is an important opportunity to correct really grievous illegalities that hurt our clients. And that's really the important part of it for us and for our clients. So I think Kelly said, but please, so long as I can quickly answer a question, if you interrupt with the chat, and then Kelly will let me know that you have a question, and I'll try to answer it quickly as we go along, because otherwise we'll never get to that. And the one other thing is I wanted to mention is that as I was preparing for this program today, which I updated it I had done it about 5 years ago, but I was doing updating on cases that you'll see at the end, but I realized that in the 5 years since I had presented this, there had been a lot of cases involving Section 8 and the False Claims Act. And many of those cases were filed by the Legal Services Program in Nevada. And I noticed that one of our current attorneys, Chris Bergstrom, is counsel of record for those cases because she was the she was a director there at the program in Nevada before she came to Pittsburgh. So she's on this call, and she indicated that she would be more than willing to jump in and answer any questions as well, or offer her sage advice and wisdom as I speak. So Chris, thank you, and please interrupt, and Kelly will see you interrupting, and then it would be great if you could add your own experiences and in anything I'm saying wrong or not enough of. Okay, so we'll begin. So the purpose of the Federal False Claims Act is to essentially encourage citizens to be tattletales. When this law was enacted, and the next slide will show, is a long time ago, the government realized that the government cannot be a police officer for all of the people and companies and programs that it funds. And so this law really encourages, but it wants to make sure that the funding that the government provides for whatever purposes, that the money is being spent in the way that it should be spent and not being exploited by the recipients of those funds. And so this law provides a procedure that encourages people who see that the funds are being misused to tattle on those people in a way that will protect the fisc, the government fisc, and severely penalize entities and people who misuse those funds. And so that's what legal services has learned to take advantage of in Section 8 side payment cases and other types, similar cases too. So here's one quote from a Fifth Circuit case from several years ago. To aid the rooting out of fraud and serve as a posse of ad hoc deputies to uncover and prosecute frauds against the government. The law was enacted in 1863, and it was proposed by President Lincoln, and the government and this Congress passed it then, and it's been in effect for a very, very long time, with a few amendments which have been, we'll mention as we go along since then, but not a lot of amendments. It's the law. I mean, I think that people probably have heard about how Medicare has, the use of Medicare funds has been the subject of many Fair False Claims Act cases for unscrupulous medical providers who make claims against to the government for fraudulent medical services that are claimed to have been provided. And the law has expanded to cover far beyond that. And a couple of years ago in Allegheny County, there was a very, very large lawsuit filed against, I can't remember the name, but it was a company that offered loans to, a private company that offered private school loans to students. The company was charged with fraudulently, and then because there was an incentive by the government, as you know, in these private schools to give loans out to students, and it was clear that they were getting these government subsidized loans and giving them to students when they knew that these students would have no way of successfully completing the program anyway. So I think there was ultimately a settlement that was for hundreds and hundreds of millions of dollars. This is essentially why that, these federal grants and contract programs would be impossible to operate if there wasn't a way to be able to enforce them with this False Claims Act. So what happens is that, what happens is that any agency or entity or person that receives a federal grant or contract must certify as a condition of obtaining those funds that the funds will be used legally and within and properly. And once there's a certification, then it's a violation of that certification if they're fraudulent or misused in any way. And that's where the False Claims Act comes in, to be able to say you certified that you were going to use these funds properly. And then if there's somebody who can establish that these entities, these recipients actually were using the funds improperly, then the certification itself establishes that they are fraud because they're violating what they explicitly knew they were not permitted to do, and they promised the government otherwise. So this is the statute, the Federal False Claims Statute, and the essential language of what this statute does is this: any person who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval to the government knowingly makes, uses, or causes to be made or used a false record or statement material to a false or fraudulent claim. And that's where the certification comes in, a false, because you have to make a false record or statement. This isn't for actually, this law does not require that somebody actually prove that money was stolen from the government, but rather that they make a false statement in order to obtain those benefits from the government, is liable for a civil penalty plus 3 times the amount of damages sustained as a result of that. But the good part, a good part of the statute is the following: that it's not just the government that can bring an action. The law specifically, for the reasons we talked about, the law specifically allows private entities, private persons, in fact, it says person, but since the Supreme Court, I guess, has said that a company can be a person too, but in any event, it allows us, on behalf of our clients, to bring a civil action for a violation of that section itself. And the action shall be brought in the name of the government. A person who chooses to bring that kind of an action is called the Relator, R-E-L-A-T-O-R, and as you'll see, all of these lawsuits are always captioned as United States ex rel, which has something to do with Relator, ex rel, and then the name of the plaintiff. And we'll be talking about how this happens, what the procedures are, but that's what, but this law allows you to do that. And then that therefore means that you, on behalf of your tenant and your client, can then obtain, as you'll see, a significant portion of damages if liability is found. So the better reason is this opportunity. So once a lawsuit is filed, a false claims lawsuit is filed, the law requires that, and we'll talk about this, how it's to be filed, that if there are damages and if the government takes over the case, which it has the right to do, then the tattletale is, even if the government takes the whole case over and your client does nothing, and you as a lawyer do nothing more other than to have filed this lawsuit to begin with, if the government takes it over, then your client will receive a portion of the proceeds of the litigation, the portion of the penalties and a portion of the damages. And if the government chooses not to proceed and you as a lawyer on behalf of your tenant choose to proceed with the case on behalf of the government, then you get an even greater portion of whatever damages and penalties result. And Chris is up there. I see Chris, so that's great. And so if you do too, then if you raise your hand or something, if you want to butt in, then I can see that too. So thank you. So this makes this opportunity even more enticing to me, at least, and I hope to all of you. Any person that's found liable under this law must, and this is not discretionary, it must be assessed a civil penalty of not less than $5,000 and not more than $10,000 as adjusted by this Inflation Adjustment Act, plus 3 times the amount of actual damages, plus plus whatever lawyers' attorney's fees have been sustained, plus costs and expenses. Although there is some discretion in that judges take advantage of. We could talk about that later. The fact is that this particular statute is mandatory, that if there is a liability, then these penalties must be imposed against the defendant. That's a lot of money. And we'll just talk about why it is, particularly with Section 8. Yeah.
I just want to say, when we started doing these in Nevada, we started filing around 2015, 2016. And by the time I left in 2019, we had gotten judgments or settlements totaling over $500,000 for the case that we did. Either because we settled and got some money, or the court awarded us a judgment. So it's, Eileen's not joking when she says there's some money there.
Yeah, it's incredible. We'll talk. Yeah, that's. But that's even better news, which happened since I last had a case in court, which there was an amendment to this particular law that allows for the government agencies to increase those statutes in every single federal law, which allows for statutory penalties. It mandates actually that the heads of the agency shall adjust those monetary penalties for inflation, so that the $5,000 to $10,000, which I had to, which my poor clients were limited to when I was represented, when I had my 2 cases that I did, they're far greater now, the amounts of money, those amounts of those statutory penalties. And if you can see here, the range now for these mandatory statutory penalties, the minimum penalty now is $11,665 per violation, and the maximum penalty is $23,331 per violation. That started a couple months ago. So it's like unbelievably lucrative for those tattletale relators, including if you have the opportunity to litigate, it's for your tenants, assuming that, of course, that the defendant has the funds to pay those judgments. So this is just to indicate that there were 2 major amendments to the Federal False Claims Act over the years, but there's but Congress still has ensured that that this law encourages people to do the tattletelling. And the most recent law in 2009, as it indicates, that came about to expand the scope of the law and to make it easier for relators to tell. The law actually expands the rights of whistleblowers to protections if they do tattle on the agency. But it was done really because of the mortgage crisis that happened in 2008, and remained with us for several years and still does, but and does now for different ways, of course. But in any event, these 2 laws, these amendments were really to expand and make it easier for litigation by relators, which is kind of shocking that there was a law that makes it easier for private citizens to possibly earn a lot of money. But of course, the benefit for the government is that the government is not wasting a lot of money if in fact they can stop that waste. So this is what the plaintiffs would have to prove about the entity that is being sued, that the defendant has knowingly presents or causes to be presented a false or fraudulent claim for approval of payment or for actual payment. So it doesn't even have to be that the defendant was actually paid wrongfully, but just that they presented a statement certifying that they should be paid a certain amount of money and they want that approved. Or that they knowingly make, use, or cause to be made or used a false record or statement that's material to obtaining that improperly requested payment. And again, the knowing and knowingly was expanded in 2009 to make it a broader application, that either the defendant has actual knowledge of the information or acts in a deliberate ignorance of the truth or falsity of the information. So it doesn't, so the scienter doesn't have to be actual knowledge, but that the defendant would act in deliberate ignorance of the truth or falsity, or acts in reckless disregard of the truth or falsity of the information. And specifically, the law now provides, this is one of the newer amendments, it does specifically, the law does not require proof of a specific intent. Chris, did you want to add something?
I was going to say, when we did these cases, this was always the landlord's main defense. They almost never denied taking the payments. They would just say they didn't know they weren't allowed to charge them, or they didn't know it was a program violation. And of course, in almost every case, the judge said, no, you signed the contract. The terms were very clear. You can't claim you didn't know. But I would say this is, if you're going to do these lawsuits, you do want to make sure before you file, because the few cases we had where this was an issue, someone at the housing authority had told the landlord it was okay. We had a case that we had to settle for $6,500 instead of the $65,000 we'd asked for, because one of the lower level caseworkers had told the landlord that they could charge pool fees. And she was wrong, and they weren't allowed to. At the housing authority itself, when they sort of, from the main office, said, no, that's not right, you can't do that. But that was enough to confuse the issue for the court to say that, the landlord didn't actually know, because they'd been getting this different information. So you do want to make sure that your housing authority hasn't given the landlord the opposite message. And similarly, you want to make sure with the housing authority that their operating procedures say that they're going to terminate the landlord if they try and charge side payments, because that was an issue in some of our cases too, because our housing authority wouldn't terminate landlords for side payments. And so the landlord would say, well, it's not material because nothing would have happened to us. And so our argument was always, well, it should have, because the operating procedures say this, and there would have been consequences, besides termination. You would have had to pay back some of that money. There would have been issues. And we usually were able to get by on that. So that's just something you want to look out for when you're sort of filing this and considering what to do. Does your housing authority actually terminate people for this? Would they, and have they been giving out the wrong information to landlords? Because the caseworkers don't always know what a side payment is. I mean, they know, a straight up extra rent, but if someone calls it HOA fees or pool fees, or, whatever name they're going to come up with, it, non-rent operating costs is another one that we saw. They may not know that that's a side payment. So it's just something you want to check before you file.
Yeah, good points. We'll keep going. Okay, so when does a defendant make a claim that was fraudulent in the eyes of your client, the relator, in the context of Section 8, but any plaintiff, and what is a claim? And again, it's a more expansive, this also was a term that was expanded to make it easier to prove wrongdoing. Means any request or demand, whether under a contract or otherwise, for money or property, and whether or not the United States has title to that money or property, that is one presented to an officer, employer, or agent of the United States, or it has been made to a contractor or other recipient grantee, if the money is to be, I said, spent or used on the government's behalf. And if the United States, one, provides or has provided any portion of the money requested or demanded to the defendant, or two, has agreed to reimburse the contractor grantee. And this was expanded also to include contractors in 2009. So it's not just government agencies or specific grantees, but if the grantee, for instance, were to subcontract, that also is a money to that subcontractor is a claim that is covered by the act. So what are the procedures for instituting a lawsuit by a private party? Like our clients. One, there are some cautions to be to have to observe. Under this law, if the alleged illegal conduct had previously been publicly disclosed by any other entity, then your client is not going to be able to succeed in the case. They're prevented from succeeding, because really this law is really intended to be used to advise and inform the government that something improper is happening, and not simply for your tenant to say, oh, I read about the fact that my landlord is doing something wrong, so now I know it's wrong, and I'm now going to make a claim to the government because of that. This law cannot be used for that reason, because the goal is your client is a private attorney general, in a sense. They're taking on that role of investigating and being aware that there is wrongdoing. And if your client has only learned of the wrongdoing because of the wrongdoing was publicly disclosed, then they're not carrying out the purpose and intent of this law, and can't avail themselves of it. So publicly disclosed means in any federal, criminal, civil, or administrative hearing in which the government is a party. So that could sometimes be a critical factor, which you might be able to, for your client, still be able to avail yourselves of this law if the government, if the proceeding in which this wrongdoing was exposed was not one in which the government or its agent was a party. If there was some sort of investigation by a Congress or by the GAO or any other federal agency about the issue that you're complaining about, or if it was publicized in the news. There is a caveat to that, though, unless the action is brought by the Attorney General and your client is the person bringing the action, is an original source of the information. And original source means somebody who has voluntarily informed the government of the wrongdoing, so that if your client was the person that had spoken to the press, and the press said, based upon what the client says, then look what's happening to Section 8. Then that, if you can prove that that was the first person that brought to the news media the issue, then they can attempt at least to avail themselves of this law. Or if your client had independent material knowledge, and material is the important word there, which adds to the public disclosures, and if that was previously voluntarily provided. So it can't be that your client was under the gun because they were going to be arrested otherwise, so they decided to tattle. That's not so voluntary. So as I indicated before, so this is how this works. Did you raise your hand, Chris? I'm sorry. No, okay. So this is how it would work if you were to use this law. And again, we'll talk about the types of side payments where I think we've all possibly, I think we all have seen or it's definitely prevalent for Section 8 side payments. And but a person files a lawsuit. You file the lawsuit, and however, it's has to be filed under seal, and it will remain under seal for at least 60 days. So this is a new way of filing the lawsuit. You're not allowed to tell the defendant that you are filing the lawsuit. Unlike, don't give notice to the defendant. You prepare a complaint, you file the complaint with the federal district court, and you as the attorney also have to simultaneously submit to the United States Attorney a summary, a fairly specific summary of all the material evidence and information which you have obtained. Actually, I guess my parentheses there it says in advance of filing the lawsuit. I could do it simultaneously though. In advance, you have to send the government lawyers basically a summary of what information you have to prove your case that the defendant is doing wrong. Then affords to the government its right to proceed, because they are the Attorney General, right? So it gives them the right to proceed based upon your client's tattletelling. It gives them the right to proceed against the defendant. But the government has three options. One is to intervene and take over the case, and that's what every private lawyer loves, but it doesn't usually happen for Section 8 cases. And mostly, in fact, I actually, there's one case, it was very early on, where in Florida, where the government did take over the case, but mostly the government will not take these cases because it doesn't involve the hundreds of millions of dollars that Medicare fraud, for instance, involves. But that's one option the government has. Or another option actually is to determine that there is absolutely no merit in the case, and they'll ask that the court dismiss it. And fortunately, in my experience, at least, and from what I've known and seen, the government is, if there's even some basis for proceeding based upon the legal issues, the government will not take that drastic step, and instead take the third option, which was to decline to take action on its own, but allow the private person to pursue the case. And that's what commonly happens in these Section 8 type cases.
I would just say you might need to be prepared to do some education with your AUSA. And when we started doing this in Nevada, we had to sort of explain what it was we were doing, because he'd obviously never heard of a Section 8 tenant filing the False Claims Act. Yeah. So that then they'll be sort of more supportive if they know what's going on. We were lucky our AUSA loved these cases, because as far as he was concerned, this was free money with no work. So
I figured that.
Very supportive, and even helped us with settlement negotiations sometimes. And even in one case that I had where my client died halfway through, we dismissed the case and he refiled because there was some fairly substantial. The landlord actually left a voicemail with his name admitting that he charged the side payments and saying it was okay because he was allowed to do that because the client had agreed to it.
What a great gift.
Helpful. But so the AUSA was like, well, if I have an admission on tape that he did this illegally, I'm just going to file on my own. So getting the AUSA on your side, that's worth sort of taking some time to work with them and tell them kind of what you're doing, assuming they're interested.
It's terrific. Another reason to think about a week from now. Statute of limitations is actually statutorily prescribed, and it's pretty large. So you can sue for damages for 6 years after the date on which the violation occurred. Lots of people don't know that the facts to know that that the improprieties occurred. So it's 3 years after the date where the material facts are known or should have been known by the official charged with the responsibility. But so that even expands, if you can make this argument, expands to up to 10 years after the after the violation occurred, whichever occurs last. And so in my experience, Chris, maybe you can tell me otherwise, but in my experience, when I have filed the cases under seal, as a previous slide indicated, you have to wait at least 60 days, and the government is required to, under the law, to make its decision within 60 days. But no, because the government takes its time. And in fact, both of the two cases I've litigated, the government would always file motions to extend the time that we have to investigate. And it's been even more than a year before they make their decision.
We never had any that lasted that long. And I think once Troy, our AUSA, once he kind of got the gist of it, they tended to come back a lot quicker. Although I know by the time I left in 2019, he was telling us he had to send it back to the DC and get it from DOJ. He couldn't sort of authorize stuff on his own anymore. So that might be causing a delay now. But normally, before that, he was pretty quick once he understood what we were doing. But the first couple of times, it definitely took more than 60 days.
Another reason to consider a week from now as well, or number of days it is from now, because those DOJ, those AUSAs will be reappointed. Yes, I'm not going to overly emphasize how important what Chris says is that a lot of what will happen in your case depends upon how sympathetic your assistant U.S. attorney is to this case. Also, the tattletale, the relator, has to be the first person to file the case against the particular defendant, or they're not entitled to any recovery at all. So also in keeping with the spirit and the intent of the law, and no public disclosure. And the final caution is that the relator is not permitted to discuss the case with anybody at all, neither you nor your client, except you can to your colleagues. But the court can dismiss the case if there has been if the situation has been made public by the relator, or even by the relator's attorney, if it's become publicly known, because obviously it would interfere with the government's investigation otherwise. So now we'll get to Section 8 itself. So so there has to be a violation of the compliance with a contract that the landlord has entered into with the government, in order that would result in either the promise to pay, or the request for pay, or the actual receipt of money from the government that would be improper. There has to be some sort of a contractual agreement between the landlord and the government agency that you can show that the landlord is violating. And in addition to that, the administrative plan under Section 8, that is the annual the annual publication by the housing authorities of what their responsibilities and their administrative obligations are to running the Section 8 program. There are definitely regulations that and the HAP contract itself and other documents that we'll get to on the next slide, which establish that commitment between the landlord and the housing authority. I'm sure you all are aware. Hopefully the Section 9, this particular regulation is quite explicit, right? The total of rent paid by the tenant plus the housing assistance payment cannot be more than the rent to the owner that the housing authority, of course, establishes. All of our tenants get those notices that say that the rent to owner is $800 a month. The tenant's portion is $100 a month, and the owner will be receiving $700 a month from Housing Authority. And that regulation also requires that if the owner gets any excess payment from any entity, including the tenant, the owner must return any excess to the Housing Authority. That's explicit. And this provides valid reason to argue that that there's been an improper and illegal side payment if the landlord receives more than that amount of money that is prescribed by the Housing Authority. Similarly, the owner may not demand or accept any rent payment at all from the tenant in excess of this maximum, and must immediately return any excess payment to the tenant. Same thing. And whenever I litigate these issues, I always ask, and if my client hardly ever has, but we have to look at the HAP contract itself, the Housing Assistance Payment Contract. Although Part C is the addendum, as if you don't, I'm presuming that you all understand, the mechanics and the requirements of participation in the Section 8 program, and are hopefully familiar with the tenancy addendum. But perhaps I'll just quickly back up and summarize that when a tenant is a participant in the Section 8 Housing Voucher Program, Housing Choice Voucher Program, the tenant and the landlord enter into a lease. But as a prerequisite to receiving the Section 8 subsidy, the landlord and the Housing Authority enter into a contract, the Housing Assistance Payments Contract, which prescribes and regulates the roles and responsibilities of the owner and of the Housing Authority for purposes of the Housing Authority then paying the subsidy to the landlord for the rent that the tenant does not pay. So this Housing Assistance Payment Contract has 3 parts to it, and Part C is the tenancy addendum, which is explicitly a third-party beneficiary part of the contract, which explicitly says that tenants have the right to sue or defend for violations of any part of that tenancy addendum, and that tenancy addendum must be incorporated into whatever private lease has been entered into between the landlord and the tenant. So Part C always is part of that lease. And explicitly in that HAP contract, Part C is the following: the owner may not charge or accept from the family or any other source any payment for rent of the unit in addition to the rent to owner, which is the rent obligation that the Housing Authority determines the tenant must pay. Rent to owner includes all housing services, maintenance, utilities, and appliances to be provided and paid by the owner in accordance with the lease. So this language is critical, because then we're going to see how it's these side payments, these illegal side payments can be much more than just an extra amount of money over and above the rent that we pay.
Eileen, I'm sorry, this is Kelly. If I could just interrupt, I'm going to launch the first of the 2 CLE polls. So attorneys requesting credit for your participation, please respond now. You'll have 1.5 minutes to do so. There'll be a second one coming up later. Thanks. And Eileen, please feel free to continue.
Okay. And Kelly, did you make Chris a co-host?
I did.
Okay, so we aren't able to do that. So if you could just remember to give Chris the credit also for being the co-host on this.
Absolutely. I've already noted it.
Great, thank you.
Thanks.
Okay. I like to get the perk as well as everybody else of our CLE. Another source of legal imprimatur on the contractual obligations between landlord and Housing Authority is from the Housing Choice Voucher Program Guidebook, which is not it's not a binding legal document, but it has been cited frequently in court cases as guidance that should be adhered to. And in that Housing Choice Voucher Program guidebook, which actually I urge people to take a look at for any Section 8 case that comes up that you're dealing with, because it does provide for some additional information that might be useful in your defense of an eviction, for instance, or in defense of a termination. In any event, in this guidebook, HUD defines fraud and abuse as a single act or pattern of actions made with the intent to deceive or mislead, which constitutes a false statement, omission, or concealment of a substantive fact. Fraud and abuse result in the payment of Housing Choice Voucher Program funds in violation of program requirements. Couldn't be clearer than that. That's when fraud and abuse occurs. Again, the payment of more than just what the contract, what the HAP contract provides and what the lease provides is a violation of program requirements. Again, in the guidebook, it provides that an owner landlord's collection of extra or side payments of money in excess of the tenant portion share of rent constitutes fraud and abuse explicitly. And there's also HUD issued in the Federal Register a fraud alert, which outlines generally to this is an old fraud alert, but it's still in effect, that essentially explains to the housing authorities that they should watch out for landlords who are demanding money beyond that rent to owner payment, because that will constitute fraud as far as the housing authority and HUD are concerned. So when you plead your case, then that's what these are the documents which you can allege in your complaint that gives your client the legal right to assert that that there's been fraud or abuse because of the side payments. I didn't put in this slideshow the fact that there's also, and I should have, I think I'll do that to fix it up, but there is a provision in Part C of the tenancy addendum, Part C of the HAP contract. There is a specific provision in that addendum that states that, or else it's it could be in Part B now, I don't remember, maybe Chris you do, but either in Part B or Part C, there's a specific provision that provides that by signing this HAP contract, the landlord agrees that every payment made to the landlord is a certification, constitutes a certification by the landlord that the money the landlord is receiving complies with program requirements. And that, pardon me?
I think that is Part C.
Okay, Part C. So that's a critical part of the analysis as well. That if you remember from back at the beginning of the slideshow, it talks about the fraudulent certifications to the government. So every time, so when the housing authority sends out its monthly payments to the landlord, and the landlord receives those monthly payments and doesn't return them, and if it can be shown that those monthly payments are being received, and the landlord is still taking extra money from the tenant, then that's a fraudulent certification that the landlord is complying with these program requirements. And that provision actually should also be alleged in your lawsuit as well. So I'm going to go on and discuss some of these cases that have been published over the last several years. But are there nobody has any questions about?
There's one question. Someone asked if filing a UDAP claim in the eviction proceedings and asking for treble damages affects the right to the action.
Yeah, very good question. I'll answer it. I'll answer it later because I have for half an hour to go, and I want to do it in the context of the case where this issue comes up, which happened to be my case, and one of my cases. So, well, I promise we'll get to it. Okay, so I have created a list of what I think is every single case that has been that there has been some sort of a published opinion on, even if they're not, published. Some of these are unreported cases, but every one has been published on. You can find them in the Lexis or Westlaw search. What happened is that in the next slide, I think it's in the very first case that some genius from legal services raised this issue of an illegal side payment constituting a false claim was in 1993 from Michigan. And that's the very last case I have cited on this list. But that's where it started. A legal services lawyer was creative and daring enough to file a lawsuit for exactly this type of a case. And the court in Michigan determined as precedent, as national precedent, that yes, this type of behavior on the part of a landlord does constitute a false claim that's punishable and by the False Claims Act, and that's covered by the False Claims Act. So since then, there have, and when I litigated my two cases, that was in 2015 and 2014 was when those were settled. None of these cases on this slide had been published. One thing you can see is that most of these cases don't make it to the circuit court. This one case, which I'll mention in a couple of minutes, did in a underlying issue actually, but what happens is that most of these cases either, except for the Nevada cases, which you were very brave but most of these cases are involve defending motions for dismissal under the motion to dismiss rule of 12b-6 in federal court. But what happens is that when pretty uniformly the courts, if the pleading is sufficient by you, most of these courts, based upon that 1993 case and then the subsequent cases, have denied the motions to dismiss. And when, or at least in some major part, they deny them. But when they do deny them, that's when the landlords are very much incentivized to settle the cases. So that's why there's not a lot of appellate law, but there are these, fortunately, district court cases that have issued opinions which help bolster all the succeeding cases to support this idea that Section 8 side payment issues are clearly actionable under the False Claims Act. And now there's a whole bunch more cases than there were when I last did this kind of lawsuit, which I'm really happy about because we have a new case in our office. And Chris, I'm going to ask us to co-counsel. Anyway, so actually the most recent, I've just put the data in this case because this is just hot off the press. This was a month ago, well, 2 months ago almost now, but less than 2 months ago. And this is the most recent case that I found published, that involves Section 8. And that case was actually this Jenkins case is more of a kind of a unique case as far as I can tell, but it's also very creative, and it could give us more ammunition for trying to litigate this type of a case, because this is really a different type of case than just the illegal side, than an illegal side payment case. This case was brought against a landlord who had failed repeated. This is more than one tenant, but this where the landlord had failed an housing quality standards inspection, HQS inspection, that, as hopefully we all know, is required to, landlords are required to comply with the housing quality standards that are expressed in the federal regulations for the condition of the property. And if not, then they're not going to be entitled to receive the housing payment, the HAP, housing assistance payments from the housing authority. And, but in this case, the inspection occurred and the landlord failed. And the allegations of the complaint were that the landlord, after the failure, made only decorative, superficial repairs to the property, because it didn't want to spend the money to actually rectify the problems of that caused the failure of inspection, but only to do sufficient beautifying, I suppose, of the property in order to somehow convince the housing authority that the place should pass inspection. And the allegations in this lawsuit were not that the landlord actually received the money, although of course, I guess as you know, the landlords are given enough, sometime 3 months, sometimes a month, maybe longer, to be able to make proper repairs in order to pass inspection. But this particular landlord was re-inspected and again failed. And I guess the housing authority inspectors were not bribed, like sometimes I know they are, or, corrupted, whatever, but regardless, they did fail again. So this wasn't a case where the landlord actually had ever received the funds after being told that they better make the repairs, and then they didn't properly make the repairs. But even so, the court denied a motion to dismiss this case based upon the certification of the landlord that they understood that this was the requirement of participation in the program, was to keep the place maintained in compliance with the housing quality standards, and the landlord had deliberately failed to do that and expected to continue, and did continue to receive those housing assistance payments while saying, come back, housing, the landlord has to contact the housing authority, said, I made the repairs, please come and re-inspect. So this is a unique case as far as I know, at least published in our research programs. But it's new, and we'll see what happens with this. But we all have experience, I'm sure, those of us who've had experience with Section 8 cases where our tenants tell us that the landlords didn't really make the repair, like the leaking ceiling, and all the landlord does is put a new false ceiling up, but doesn't really fix the roof or what, something like that. So, but this is pretty unique. All the other cases really do involve mostly some sort of payments which are not, which were not provided for, not permitted by the HAP contract. So this, the next case, Ellis, it was actually there was a summary judgment. I think this was a Nevada case. Yeah. Maybe, do you know anything more about this? But this was newly issued too.
Work on this one as much. I just remember that the landlord was pro se, which is why it went up to the Ninth Circuit. She went to the Ninth Circuit, so she just didn't want to accept the law, and that's why she kept appealing.
Landlord, yeah. Yeah, this was pro se, and the judge granted summary judgment on behalf of the plaintiff. This was the landlord admitted to having demanded and received.
Thought it was okay.
Thought it was okay, and so summary judgment was granted to the plaintiff for hundreds of, like more than $100,000 of damages, and the defendant appealed to the circuit, and the circuit court said, actually wrote an opinion, not just summarily affirming, but explaining why the landlord was wrong and maintained those damages, that award against the landlord. Carmichael, there's two cases there and down here, the same case, because this is something which is interesting about federal law, which I encountered in the cases I had done, is that in this case, the landlord in this case, it was a failure to pay, a standard extra side payment issue. And a default judgment was entered for a ton of money also. And I'm going to explain a little bit about what damages you can get, but a ton of money. And it was a default judgment. A year later, landlord comes back to court to ask to vacate that default judgment. Now it's unlike state law. The opportunity for a defendant to try to vacate a default judgment is much broader. It's more lax. And actually that happened in my case with one of my cases. The landlord had neglected to respond to the lawsuit, and so eventually you have to give certain notice that you're going to get a default judgment. The landlord neglected to do what it was required to do by that notice, and I then obtained a default judgment in my case. But the landlord then got a lawyer and acted pretty promptly after that. And even though it would never have flown in state court, the default judgment in one of my cases was then opened, and we had to then proceed with the litigation. So that's just something to be aware of. It's not over when you think it might be over always, but in this case it was. The court did not grant the motion to vacate the default judgment. Jansen, this is also one of your cases, Chris, where there was an opinion issued in a case where the federal court was actually ruling on the motion for to grant IFP status, because under federal rules we don't get there's not the same automatic if you get represented by legal services rule, although that helps. But the judge has a duty to evaluate at least the prima facie merits of the case. So in this case, the judge did grant IFP status, but it's a helpful case because it's 2019, and it does a somewhat of a decent review of these other cases upon which the court relied to say, yes, it seems clear by the complaint that there's a meritorious cause of action here. Kelly, this is 2018. So this involved two allegations of fraud, one being the extra side payments, but also in this case, in California there, and it may be in some of your area counties as well, there was a rule in California, a law in California that requires that an occupancy permit be obtained, which involves showing that the place was habitable also, and that the number of people that are being rented to doesn't exceed the number of bedrooms or whatever it is, whatever those rules were for occupancy permits. Every renter, every owner in California has to obtain an occupancy permit. And because the HAP contract requires also that a landlord certify as part of its the requirements for being part of the Section 8 program, they have to certify that all federal and state laws have been complied with for the rental of the property. And in this case, the landlord signed that, and it was found out that there was no, that the landlord had never obtained an occupancy permit. So not only was there the additional side payment, but also the fraud concerning the occupancy permit. And the court held that both of those lies, I suppose, were actionable under the False Claims Act. So that's something to look at as well. And also that's an interesting, in light of the fact that there was some discussion recently on the listserv, on our plan listserv, about does the failure of a landlord in general to get an occupancy permit that's required constitute an affirmative defense against the tenant being evicted? And the law's not great on that. Although I forget who it was that maybe the person who's on the listserv, who did the case on the listserv is on here, but she successfully defended for claim damages as a result of not, the tenant had already vacated in that case. But it's a hard, I think it's a difficult issue, challenging issue in state court, but it can be used to claim a False Claims Act liability if you have Section 8 tenant facing that issue. So let's see what other cases I've highlighted here. The Johnson case. So in this case, again, this was discussed at the IFP stage, and or maybe this is the case that I was thinking it was the IFP stage, but this was where the claimed illegal side payment was the sewage and trash fees, because the HAP contract, and I think it's page 1 of the HAP contract of Part A, really specifies what utilities is the landlord going to be responsible for. And sometimes those often they contradict what the lease says. So what is dispositive is what is in the HAP contract for purposes of a side payment argument. And in this particular case, the HAP contract provided that the landlord has to pay for the water and for the sewage and trash fees, and the landlord was charging the tenant, and the court said that's illegal and that's actionable.
Almost all of our cases, the extra payments were never called rent. They were HOA fees, pool maintenance fees, sewer and trash, a lot of sewer and trash or other utilities, which sometimes, of course, like they were charging way more than the utilities because they really were rent, but they almost never called it rent. I think I had one or two cases where the landlord actually signed a deal with the tenant saying, by the way, you're going to pay this extra rent money because the housing authority won't get my full amount, and they actually put that in writing and signed it, which was helpful. But they called it rent. But other than that, it almost always was something that sort of landscaping fees, HOA fees, pool fees, sewer and water.
Yeah, no, I think I flagged those cases. This one from California, this Terry case, was an allegations that charging for a washing machine and dryer fee and renter's insurance and covered parking fees. So that case, it was not, the court held, because actually that what they analyzed here in this case, what constitutes rent for purposes of violating the certification, the housing authority certification. And the court here held that washing machine and dryer was definitely considered to be rent fees for those things because it was mandatory. I believe they also said that for renter's insurance, that the landlord had was mandating that the person obtain renter's insurance. And so because that wasn't in the HAP contract, or that therefore it was an illegal side payment to require that, even though the money, I guess the money was actually going to the insurance company in that case, I'm not sure. They did hold, though, that the parking fees, they were going to they remanded to determine whether that was a mandatory fee, because that was how they analyzed whether it was an illegal side payment or actionable under the False Claims Act, was whether it was a mandatory fee that the landlord was asking for in violation or contrary to the terms of the HAP contract. So this case, Doe and Gormley, that case involved a not a standard Section 8 tenant, but somebody under the HOPWA program, the Housing Opportunities for People with AIDS program, which is also a subsection of Section 8. So it's not just standard Section 8 tenants that are entitled to these laws to proceed with the lawsuits. And Holmes is the case that Chris referenced, where this was, there were homeowners association fees and also management fees that were being complained of as illegal side payments, and the court held, yes, those are deemed to be illegal side payments.
And that was too, because she didn't actually pay the HOA fees for most of the fees that we claimed as violations. But because they tried to evict her on it, the court didn't give us a problem about saying that actually was still another fraudulent act, even though she never actually paid it. So it cut down her direct damages, but they still held that each month was a fraudulent act.
Wow, that's awesome.
Yeah,
so I'll just go for a few more, because I don't have too much more time. But the Mathis one, I thought this is also your case. Your office is the queen, is the king of these cases, really.
Payments case, where
Yes.
The caseworker actually told them, when we did discovery, the caseworker told them it was okay.
Oh, okay. But on the other hand, the court held that even a payment for being able to use the swimming pool in the complex would be considered a violation if it's not in the contract, in the lease or the HAP payment. So I guess the court eventually said, well, there was justifiable reliance on the housing authority, but
we didn't get it. We settled before the court could do that, because it was pretty clear that it was not going to go well. So.
Oh, okay. But still, I just, even a pool payment. So check those documents.
They had to pay it or they would get evicted. So it was still a side payment.
Right. So that was a kind of a fun case, I think, except when you realized it wasn't going to go well.
That wasn't so fun.
So so these two cases are mine, Salvador and Fleming and Richards. And Salvador, this was the case where, now I will answer that one question that somebody posed. So the case came up first, of course, as is often the case, as an eviction case. And so my client had proof. She really had lots of proof that was blatant, that she had been paying these side payments and didn't realize it, that it was improper for a few years. And so in the eviction case itself, I filed an unfair trade practices claim, which actually is under the FCEUA, the Fair Credit Extension Uniformity Act, which is the law which deals with demanding more money that the consumer isn't entitled to. But that is deemed violations of the FCEUA are considered to be violations of the Unfair Trade Practices Act, which thereby gives tenants, consumers, the right to sue in private actions. The FCEUA doesn't do that specifically, but it says you have the right to do that as an unfair trade practice. So yeah, it was a counterclaim under both, relying on both those statutes. So I was definitely aware of the False Claims Act, and I was intending to file that action. We finally settled this case, and in the settlement, I forget if my client got any money under the UCC claim, but she didn't have to pay any money, and she had moved out by then, so I didn't have to worry about eviction. But I was aware that I wanted to make the claim under this law, so I expressly put in our settlement agreement that this does not waive any rights that the tenant may have to other remedies down the road or something like that. And I was very grateful I did do that, because in this lawsuit in the federal court, one of the grounds for motion to dismiss by the landlord was that I had waived that there was claim preclusion because I had not asserted, because even though I had filed a counterclaim in the state court, I didn't assert violation of the False Claims Act in the state court. But as I briefed and as the court held, that's not a valid argument to make for many reasons, but one, including the fact that the False Claims Act, your client is not really the plaintiff. It's the government that's the plaintiff. And so there was not issue preclusion, because it's really the government's action, not my client's action. And therefore, there was no claim preclusion. And there's some case law on this, which actually this was, every lawyer's dream, where the other side relies on a case for the opposite proposition. And all I did was find a case that expressly overruled the case that they were relying on. So that was fun. But anyway, there's this. So I think the next slide, I hope I did this, but if not, I'm going to talk just very briefly about, yes, I did, about the leverage and why, however, I learned from this case in my settlement negotiations that it probably makes more sense not to assert an unfair trade practices claim in the state court proceedings, even if you want to argue that the defendant shouldn't owe any money. There's no compulsory counterclaim law in Pennsylvania. And my advice to anybody would be, instead, if you're going to be doing a False Claims Act case, raise this type of an unfair trade practice as a supplemental jurisdiction claim in the federal case. And I'll explain why in a couple minutes. So this this Richards case, there's also an opinion on this case where I was defending a motion to dismiss, and the court there expressed something which addressed something which I had to address, because the plaintiff addressed it, but I don't think it's really terribly insignificant. That won't affect us. But there are two different types of certifications that a landlord can be accused of and actionable under this law. One, and it's been a common law evolution of what these are. One is an implied false certification, and one is an express false certification. But in any event, in this particular case, the judge wrote that actually this type of a case involves both. So it doesn't really matter whether it's a false express or implied false certification. But if that comes up, you can take a look at that case and it will help you. Let's see. And the Sutton case, this is one of the newer cases also, the older, one of the original cases, where in this case, it was the extra payments for landscape maintenance. And again, it was a necessary condition of the lease, but not the HAP contract. And so, so the court held that that was a violation and actionable under the False Claims Act. So these are the cases. You can use this as a handy dandy through October of 2020 Horn book for you all. So some final thoughts. This thing about leverage, as I explained, is that this consideration of leverage, here's the problem, is that in order for your client to get 30%, if the U.S. attorney is willing to give your client up to 30% of whatever damages they are able to recover, first of all, the U.S. attorney is not going to demand so much in settlement that they're going to bankrupt the landlord, except if there's a default judgment, I would say, or except if they've discovered, which has not happened in my cases, that the landlord is a repeat offender for other tenants as well, or a large landlord. In those cases may be different. They weren't mine. So the landlord, the U.S. attorney in settlement there was no way they were going to demand all of the money that they otherwise would be entitled to had we litigated the case, which also then meant that our share of that money, 30% of it, or between 25 to 30% discretionary with the court and the U.S. attorney, was also going to be much lower than I and my client would have otherwise wanted. And so, and we didn't get huge damages like you did, Chris, which now you're inspiring me to be a little bit more aggressive, but a lot more aggressive. But what the U.S. attorney suggested, and so what I did instead is, I mean, that's why I think if you put in, what happens is if you put in an unfair trade practices claim, which also allows for attorney's fees and treble damages in your federal case, then what the U.S. attorney was much more willing to do was say, okay, we're going to settle the case as damages under the unfair trade practices, thereby giving the private litigant a lot more money than they would have had they gotten the same amount of money under the Fair Claims Act, where we would have only gotten 30% of the recovery. And that led to being able to settle the case that gave my client and me not as much money as Chris got, but at least more money than I'd ever gotten in the case, and my attorney's fees.
Yeah, we didn't get the clients that was just our total for the judgment.
No, I know, but still. And made my director pretty happy that year too. So so that's why there's a good reason to be able to have that leverage, to be able to get more money for your client in a settlement than just simply relying on a false claims case where the U.S. in settlement, the U.S. attorney would have to take 70% or between 75 and 70%. And also the U.S. attorney still they get to decide, they get to approve a settlement. So they do have leverage over you and what you would want. And you have to be concerned that if the U.S. attorney is not willing to go for the big bucks, that you better try to accommodate with the U.S. attorney, because they have the final say. They had to get permission from the Department of Justice to, the biggies in Washington, so to settle. And there are a couple other state common law claims you can make. Unjust enrichment, which was one that I think I said at the bottom of the other page. This is not reported, this case, but this is one of the original cases, and this was taken on by the Florida U.S. attorney. And they got some, and the money, there was an unjust enrichment claim in that case, and you could plead that. I don't know if you've pleaded that in your cases, Chris, and also common law fraud. And here, oops, sorry. Recapping what the different side payments can be. Now there's under most of the circuits have argued that a separate rule of procedure, Rule 9B, that you have to plead fraud or mistake with particularity, is required in these cases because you're essentially pleading fraud. But circuits are split, and although most of them say yes, you have to. The Third Circuit has not ruled expressly on this issue. The First Circuit says you don't need to prove it with particularity, but given the other newer Supreme Court cases, like Iqbal is the big one, that requires particularity in pleading, it's not terribly difficult to meet the standard. And in all these cases, the standard was met that you have to plead specifically what happened. And it's pretty easy to do because you have the documents to show what the landlord is able to charge. And then you know what your client, assuming your client has receipts, that's the big issue, I guess, is what your client has for receipts. So anyway, and actually there's one, here, I'll get to that at the end. So there's this issue. Computation of damages, that's still not quite uniform. How do you, not for the penalties, but for the actual damages, are the damages going to be deemed, let's say your client is paying $100 a month extra and the HAP payment is $500 a month. Are the damages going to be that $100 a month, or are they going to be the $500 a month, because that's the amount of money that the landlord should not have received had they been, but they were receiving. They shouldn't have received anything because they were lying this whole time. So therefore, several courts have held that therefore the full amount of the HAP payment is what would be considered to be the actual damage for in that case. But all of the courts, but that's still a matter of debate between courts, and but all of the courts agree that for each month in which a wrongful payment was made by the tenant, that constitutes a distinct violation of the False Claims Act. And that means that up to $23,000 per violation as a penalty would be applicable to each month that the tenant made an extra payment that they shouldn't have had to pay. That's an incredibly huge amount of money. So that's why this is like shocking to us who deal with, hundreds of dollars usually, or thousands, maybe a few thousand, but not hundreds of thousands or millions of dollars. One other thing I learned just by accident, but it's interesting that this is just a thought too, that under Pennsylvania, under federal law, if you file a complaint that's the pleading is deficient and you haven't pleaded enough facts, and the other side files a motion to dismiss, then you're entitled to one free amended complaint. You don't have to get approval by the judge. You don't have to make an argument about why you should be entitled to amend. And I just found that to be very helpful. So what I've done in the subsequent, knowing that I didn't plead quite as much as I probably should have on purpose, because I wanted to see what the motion to dismiss would be. I knew that the other side is going to always file a motion to dismiss, and I wanted to see what the bases were for the motion to dismiss, because I knew I would be able to plead because I had fixed the first case I had done with a really good factual outline, and I figured I could easily do that again on my free chance to do that. So those are all these considerations, and I think I'll send to Kelly one of my complaints, so you can see one of the corrected complaints, so you can see and plagiarize if you'd like.
This is Kelly. I'm going to go ahead and launch the second CLE poll box. Eileen, if you do want to go ahead and send me the other material that you'd like people to have, I'll then put it on the Schedule app under this session so that people can go in and take a look at it and download it.
Oh, great. I won't be able to do that till a little bit later, but I'll do it this afternoon, Kelly.
We did have a couple of questions, Eileen. I don't know if you want to weigh in. The first one asked if there is any consideration of tenant culpability in making the side payment or risk to the tenant.
Yeah, thank you. I actually, that's something else I'll add on my new and improved slideshow. Yes, on that list, the Stearns versus Lane case from Vermont, 2010. In that case, there was enough evidence, according to the judge, that the landlord and the tenant had conspired together to, because the client knew, and that the client knew that there was, that it was improper for her to have agreed to the side payment, but she did it. And you'd feel bad because she was desperate, but desperate wasn't enough for the judge when she had admitted that she knew of the that it was illegal also, as much as the landlord. In fact, actually, I would say this in that particular case, Stearns versus Lane, the tenant was cajoling the landlord to do this because she really wanted this place. And so the judge found that it was a technical violation of the False Claims Act, but refused to grant any damages at all to that particular tenant. So in both my cases, and maybe Chris in yours too, I needed to be careful to know how did it happen that my clients had gotten themselves in this, and both of them were very believable to me, at least, that they really didn't know that this was improper, even though they also probably could have known, because you go through that training as a housing authority tenant. But I thought they were both credible and believable, well, and sympathetic enough that, and so I do caution you on that. To my experience, though, in neither of these cases and I've never seen, I don't know, but I haven't seen anything in writing that shows that the housing authority is willing to terminate a tenant, but for engaging in fraud, but you haven't either. So
the only time it was really an issue for us that it was litigated was the Benitez case. I don't think it made it into the decision, but they tried to argue, they spent a lot of time and money trying to argue that she knew and doing depositions. And our response is basically, she's not the plaintiff. The government's the plaintiff. There's no unclean hands here because she's the one bringing the lawsuit. It's the government, right? Bring your own FTA claim against her.
I like that. That's good.
Yeah, and that never, I don't think it showed up in the decision, but they tried to make a big deal out of it, and we sort of, did a legal version of a shrug.
The other thing, conversely, in one of these cases of mine, almost as soon as I filed the case, or maybe after I won the motion to dismiss, but very quickly the landlord wanted to settle the case, and he was pretty remorseful. He admitted it, and he had other Section 8 property, and he was concerned about there was some term, which I don't remember now, that he used about that he didn't want to be placed on a list by the Department of Justice, which would have prevented him from being able to continue to be a Section 8 landlord. And there is a term, one of these days I'll remember that term. But in any event, the government wanted to settle the case by agreeing not to put him on this particular list. And they asked me what I thought, and I agreed, because honestly, if this guy was remorseful and he learned a lesson, he did have to pay, a decent amount of money, and I didn't want to prevent the limited number. I didn't want to add to the limited number to the huge number of tenants who refused to give Section 8 to our clients. So that sort of came up in this case, in one of my cases. Right.
Other question we had, and I'll see if you have a different opinion than me on this, is whether if side payments have included washing, drying machines, does that include coin-op machines? And I would say no, because you can choose to use those or not, and it's not mentioned in the HAP contract. Although on the other hand, the housing authority does set the rent based on the amenities. So I
think I would agree it would be very difficult to prove to convince a judge that it would be considered an illegal payment. Yeah. Yeah. Okay. Anything else?
I would just, if you don't mind if I jump in, I'd say, you know, I want to echo Eileen that to the extent federal litigation is easy and fun, these are easy and fun cases. When my office started this, we were not experienced federal litigators. We had really not done much at all. We were all young. We did not know what we were doing. And Dick Tenenbaum in Connecticut was very generous with his time and pleadings when we called him up and said, you know, we don't know what we're doing, but we'd like to sue some people. So they're not resource intensive cases. They're usually not evidentiary issues. Everyone pretty much agrees the extra payments happened. All of our cases either were settled at summary judgment or were settled after a motion to dismiss. There weren't trials. There wasn't, except for Benitez, there was not extensive discovery, and that was all the other side. I guess they just enjoyed lighting piles of money on fire. I'm not sure.
Yeah.
But the one thing is you probably, again, I think I mentioned that you're going to have to educate the U.S. attorney, but you're going to have to educate the judge and the other lawyers as well, probably. Because maybe your judges here in Pennsylvania are better, but our judges in Nevada, they did not know anything about subsidized housing at all. So you need to sort of start from the very beginning of this is what a Section 8 program is, and this is how it works, and really sort of explain that, and especially explaining the money stuff, because there was some real resistance to sort of the idea of, okay, your client got charged an extra $100 a month, and I'm supposed to like award $10,000 a month. Right. For that $100 violation, and that seemed sort of unfair to them. And so we really had to sort of very carefully lay out, this is why it's allowed and you don't have a choice and it's not unfair. They're actually ripping off the government, to make them comfortable with that. And then also, you know, make the U.S. attorney comfortable with the settlements we were asking for. So that, you know, other attorneys too, like there's no attorneys who do these cases aside from legal aid attorneys. So we get some, you know, guy with maybe a landlord tenant practice, if we were lucky, like a solo practitioner who had no idea about any of this. And sort of, again, there'd be this sort of hostility. You're never going to get $100,000 for what's $800 in damages total. And so the better we laid it out, the more likely they were to settle. And then of course, once we got a few cases on the docket, that made everything a lot easier. We could file it and get a settlement because they could look up this case law and see that we were already winning.
Yeah. So we need more case law in Pennsylvania, although those are excellent considerations to think about. But yeah, so at least we need more case law in Pennsylvania so we can start getting these settlements or outcomes. And so help us all by filing them, and in consideration, we'll help you with litigating them.
Okay.
Yeah.
Thank you so much, Eileen and Chris, for your time and for all this great information. It's very helpful. Thanks to everyone who joined us, and everybody have a great day. Take care.
Thank you, Kelly.
Thank you.
Bye.